वहाँ लगाओ। रोशनी बहुत ज्यादा है। नहीं नहीं, वहाँ लगाओ। ठीक है, दरवाजा बंद कर। Good evening, students. I hope you can see me, you can hear me, and you can see the screen. Very good. Just give me a minute. In our last class, we are done with the introduction of the syllabus and our course outline, the syllabus that we have to cover in this class, and the pattern of exam and the pattern how we will be tested for these topics. And then we have a conversation about the course plan and the class technique and the class technique. And then we started our first topic, which was English legal system, right? This was the objective of our first class, which was held on 12 January 2022, right? Today is 19 January and our topic is sources of law, right? This one. This sources of law, which is the part of the English legal system, right? Okay. Before we could go to our next topic, I just want to revise. I just want to give you a quick review about the previous topic that we covered in our last class, that what we have done. If you have any question in this topic, then do let me know, right? Okay, it's a just 5 minutes review of the previous topic. All right. The very first topic, very first area is the English legal system, right? And in which we have discussed how, what is the meaning of law, how it is originated, how it is developed over year, and what are the types of law. Like I explained the, I told you a story that in the very ancient days of life, the only purpose of life was food. The people are divided into groups, powerful groups, weak groups. They fight with each other for the sake of food, right? Then they thought, if this will be the pattern of life, one day we all will kill each another. So we should have a mechanism, a system of rules through which we can live our lives. So they introduce the social, they introduce the social control mechanism, which have two branches. One is formal control mechanism and second is informal control mechanism. In the formal control mechanism, they introduce a set of rules which is called law. Law is the set of rules which you have to follow. You have no choice to not follow it. If the law, if you live in a jurisdiction, in an area, and if there is any law in that area, then you have to follow that law. If you will not follow, the state, the rulers of that area will punish you, will fine you, will teach you that you have to follow the law. And the second area of that social control mechanism was informal control mechanism, in which ethics fall. They give you a rule, they give you a corporate social values, they give you the moral values and said you have to follow it. If you follow it, then it's very good. But if you do not follow it, there is no concept of punishment, right? Okay, our area of study is formal control mechanism, all right, which is law. What the law tells us is it gives you the procedure how to deal with dispute, one purpose, Second, discourage disputes. Not only resolve the dispute, but also discourage the occurrence of dispute in future again. Right? How they discourage it? By giving the punish and fines and imprisonment to the wrongdoer, the person who is in guilt, who did the wrong act. All right. Then, after the concept and formation of law, we have studied different types of law: common law and equity law. That's the common law, equity law, statute law, private law, public law, criminal law, civil law. All right. Common law is the very early system of law, which is the law of kings, in which the society elects a sensible person out of them, who is the king, and the king decides the rule how the society will run. The judges of the kings travel around the area of the king and see who is not following the rules of the kings. If they find anyone, they punish them. Then another law was introduced after the common law, that was equity. Equity introduced the concept of fairness. That means monetary compensation is not only the compensation, but there is a concept of fairness which cannot be compensated by the money, right? Which is only compensated by the fair act, right? And then the other development in the law is the statute law, in which society realized that we have different type of issues, and we one person with specialized skill cannot handle that different type of issues, so they need multiple people with multiple skill sets to deal the different type of problems, different type of disputes. So they elect some persons from the society who are specialized in the required areas. They sit together and decide the rules for the general public. This is called the statute law, which we do usually today in the parliament. Who are the members of the parliaments? The persons who are elected by the public. And what they do, they make the laws to govern the society. So this is called the statute law. Any law which is decided in the parliament, which have multiple skill set. And then public and private law, any act, anything which affects a small group, 2 persons or small businesses, are called the private law. Anything which affects the whole public, which is called the public law, in which state itself involves and resolve the dispute, right? Criminal law is the part of public law, and civil law is the part of private law. Criminal law is the law in which a crime is conducted. What is crime? A crime is an act which is prohibited by the law, right? Which is prohibited by the law. For example, you cannot kill someone. It's a crime. So any act which is not allowed by the law, any act which is prohibited in a state, is called the crime. If there is any crime, then the effect of that crime will be on the all public. So this is type of public law, and the government gets involved and punish the wrongdoer, right? Civil law is the law which affects this small group of persons, right? Next, we have done the civil court structure and criminal court structures. The very first court is, the very small court is magistrate court, which deal with the domestic cases. Then the crown court, which hears the appeal from the magistrate court. county court, which has the appeal of contract and tort. And then there is a high court, which has 3 division: Queen's Bench Division, Family Division, Chancery Division. Family Division deal with the domestic matters, and here's the appeal from the magistrate court. QBD deals with the contract and tort matters, and Chancery Division deal with the land, probate, and equity matters. And then equivalent to the High Court, there is another tribunal is working, which is called the Employment Appeal Tribunal, right? Which is the higher version for the employment tribunal. Any dispute arise in between an employee and employer will come at the employment tribunal. And then if the parties of the case do not agree with the decision, they can make the appeal to the employment appeal tribunal. Then the appeals from the employment appeal tribunal and high court goes to the court of appeal and then Supreme Court, right? So the cases come in a large number and solved in a shape of parameter. So at the level of Supreme Court, there are very rare nature of cases exist. Clear? Then on the equivalent to the Supreme Court, 3 other courts work. One is European Court of Justice, second is Privy Council, and third is European Court of Human Rights. What are those? European Court of Human Rights are the convention, are the agreement of some European states who agree on the human rights introduced by the UK, right? So if there is any dispute, any dispute in between the law and the Human Right Act, then this will be dealt into the European Court of Human Rights. Privy Council is basically Commonwealth country is a council in which the disputes of Commonwealth countries are heard, right? And European Court of Justice, this is the court where the laws of common states are interpreted. The European Court of Justice tries to eliminate the application interpretation of the law, same law in all countries with the respect of their trades, right? And after the civil court structure, there is a criminal court structure which have the same structure. They only have magistrate court, then crown court, then only one division of the high court, Queen Bench Division, and then Court of Appeal and Supreme Court. Till now, till this thing, this is the structure. These are the areas that we covered in our last class. If you have any question, you can ask. You can hear me? Okay. You all have the detailed notes of Hamzah Academy. You have the detailed notes of Hamzah Academy? Yes. And you have gone through with those notes regarding these areas. Okay. All of you are the part of the WhatsApp group of this batch, because the group which I have only how much participant? 2 to 3 participants. Yeah. How much participants? Not yet. Okay. Yes. there are two participants in the WhatsApp group. Okay, please do request the Hamzah Academy to make you the to add you in the WhatsApp group, because after today's class I will share these short notes in the group, right? The lecture 1 and lecture 2, the previous class lecture and the today's class lecture. So it is very important that you all are the participants of that group as well. All right. Okay. uh, After the civil and criminal court structure, there is one thing which we need to cover, is the procedure. Civil Procedure Rules Act 1998. Okay, what is it? Basically, the Civil Procedure Rules Act provide the parties of a dispute the other procedure to resolve their dispute before going into the litigation. Before going to the court, they give you the opportunity to resolve your cases by other means, by discussion, by compensating each other, right? And why they do it, they just want to avoid the litigation, and they want to resolve the dispute very quickly. So this is the one benefit of the Civil Procedure Rule Act, that it provides the opportunity to the both parties to resolve the dispute before going into the litigation. And what is the benefit of it? That without wasting time, the dispute is resolved. Otherwise, if they do not agree to the solution of the problem, then a proper timetable are given to them, that one, they have to submit their request, then when they have to submit their request, when they are allowed to give their opinion, their point of view, and when they will give the evidences, and what are the time frame in which the evidences are evaluated, and a conclusion will be given to the parties. So what is the first preference of the Civil Procedure Rule Act 1998 is to resolve the disputes before going into the litigation. Clear? Okay. When parties decide they do not want to resolve the dispute out of the court, then court issue a timetable to them, which has two parts. One is tracking, and second is case management. Tracking is the procedure in which the court provides three brackets, right? First of all, you need to identify in which bracket your case falls. And then when you have decided your bracket, then you will be managing that case, which is called the case management. So what are two principles of the act is, first is tracking, and second is case management. Tracking has three brackets. One is small track, fast track, multi-track. All right. And then what is small track? In the small track, low value claim cases less than sterling 10,000. Quickly, informally, without legal representation. A very first track is a small track in which the cases which has less than 10,000 sterling monetary value are dealt in the small track. These are small cases. These are quick to handle, right? Second is fast track cases. In fast track cases, they are medium value cases in between sterling 10,000 to 25,000. Trial is no longer than 1 day. Actually, the time of solving the dispute of the fast track is in between 1 day to 30 days. Clear? Limited need for expert, simple procedure according to the timetable determined within 30 days. Trial is no longer they hear the parties within 1 day and they decide the case within 30 days. So the total duration of solving that dispute is 1 day to 30 days. All right. And then the last track is over sterling 25,000 properly managed by the courts. This is the multi-track case. These are the big cases. These involve more money. The more money, this is the highest bracket, and these are properly managed by the courts. Now, once you have decided that what is the monetary value of your case, then you have the procedure of handle that case accordingly. After the tracking, the other step is case management. Case management is basically for the multi-track cases only, because they are big in value. Multi-track, this is multi-track case in which pre-action protocol incorporates by the party. Pre-action protocols mean the preparation of first, before the case management, they are again given a chance to handle their disputes before going into the litigation. But if pre-action protocol is not fulfilled, pre-action protocol is basically another chance of handling their dispute out of the court. This is called the pre-action. Before the litigation of pre-action mean before the litigation of court, you have another chance, you have second chance of resolving your dispute. Timetable decided, dates, witness, decision, meeting deadlines, and solve the cases. Once the party decided that yes, they want to go for litigation, then a timetable issued, date is decided, when the parties have to come, when they have to express their point of views, when the witnesses have to be present, when the evidences will be evaluated, and when the decision is taken. So this is called the case management. If you have any question, you can ask. Is this Civil Procedure Rule Act 1998 is clear? Good. Okay. Let's go for the next. Okay. Okay. Our today's area is sources of law. I hope you see the screen. No. This one. Okay. Our today's new areas are sources of law, in which the very first area is case law and precedent. Case law and the precedent, in which we have 8 elements, 8 concepts to understand. One is common law and equity. Second is doctrine of judicial precedent. Third is ratio decidendi and obiter dicta, and then status of courts, court of appeal exception, persuasive precedent, overrule and reverse, avoiding of the binding precedent, and then the legislation, delegated legislation, and then statutory interpretation, and the impact of the sources of law on the Human Right Act. So these are the 3 major areas. Basically, this is 4, 3, and this is 4. These are the 4 major areas that we are going to cover in today's class. Okay. Sources of law. Sources of law. First is source of law, interpretation of law by courts, which is called the statutory interpretation. Law-making bodies like courts, like parliament, which make the common law, statute, and then delegated legislations. Statute make the legislations. What are the sources? Let's discuss. Very first source of law is case law and the precedent. Case law and the precedent. Case law incorporates both common law and equity law. What was the common law? System of rigid rules applied by royal courts, hard consequences. And when the equity law, what was the equity law? Where justice is not provided by a common law, equity law compensate parties. It provides concept of fairness. It is based on fair dealing between the parties. It improved common law by emphasizing fairness, shift from rigid rule to fairness, shift from common law to equity law. Okay, till here in the case law, we have studied the common law and equity law. Yes, it is the part of our previous lecture, which was the types of law. Why we are studying the this type of law, common law and equity law in the case law? Because we need to understand what changes becomes when the common law shifts to the equity law. The very first change is the concept of fairness. The concept of equity is introduced. Now bring the shift of common law to equity law, bring the following changes. What following changes? New rights provided safeguards. New safeguards are provided. Equity protects rights, safeguard right for which common law gave no safeguard. There are something, obviously, as the common law is the very first law, and it only deals with the monetary losses. So what the common law provides, the equity law provides safeguard? No, there is no only monetary loss. There is also loss of feelings. Someone's act may hurt someone. This is also one type of loss of relaxation. So monetary loss is not only one type of loss. There are some other types of loss which protected by the equity law, which is protected by the concept of fairness. So equity law provide more safeguards to those matter to whom common law was not dealing before. How the better procedure effective than common law is in resolving disputes? This one, better remedies provide better compensation for damages injured party. So successful claim award damages to compensate the losses. How they compensate the party? First, at very first phase, they identify whether there is a loss. Then at the second point, they need to identify how this loss affect the injured party. Third, if the loss affect the injured party, what is the compensation? What is the remedy for that loss? So what the equity law says, every type of loss should be compensated by the relevant remedy. Clear? So what remedy equity law provide? Specific performance. Sometimes it is not only possible to compensate the one type of loss by money. So specific performance, that means if you have agreed to do something, you are required to do that thing. This is called specific performance, which is emphasized by the equity law. It says if you do not have monetary loss, then you cannot be compensated by the money. So one type of remedy is specific performance, which says that the thing, the act, the performance you have committed, you have to perform that. Injunction mean abstain, restrict from wrongdoing. Injunction mean stopping someone from doing a wrong act. If you have committed an act which you will not perform, then you are bound that you will not perform it, right? Ratification, alteration of documents. If you want to ratify, if you want to alternate, if you want to change some documents, then the consent of both parties are required. If this ratification is not with the mutual consent, then it is not allowed, right? Recession, restore in pre-contract position. What is the contract position? Situation of the parties if the contract never made, compensation of loss to restore injured parties position. What is the example of this? Okay, this is very important concept, and it will be we will again read it again and again in different topics. So the understanding of recession is very important. Recession mean you are going to restore the injured party into the position he or she would have been if the contract is never made, right? What it says, for example, I want to make a school, and for the school I need furniture, the chairs, the tables, and the rostums, and all the necessary things. So what I will do, I call some vendors and take the quotations and give my order to one vendor, and decides a timeline that within 1 month before the opening of my school, you are required to send me my required furniture, right? Now, today, when I am calling the vendors for the quotation, in which position I am? I have an aim to open a school, and I have some money in my pocket, the budget in which I have to buy the furniture, right? So this is two situations in which I am. Mainly these are two situations that I have an aim and I have money in my pocket to spend for the fulfillment of my aim. So the vendor, if rejects that, no, I am after the contract, after the selection of member of the vendor, if the vendor says no, sorry, I am unable to meet your order, then how he can restore me into the pre-contract position? Obviously, for the initiation of that contract, I have given him some token money to start my work. So the court will say, I should the party, the vendor who denied to fulfill the order must compensate me, must put me into the position where I would have been if this contract is never made. What was the position? What was the position? Taking me back to the position in which I have the money, token money, which I have given to him, and the savior of time. That time, obviously, the deadline I mentioned that I want to open a school within a month, and he has to deliver me the furniture. And for this purpose, I have given him 1 month. Obviously, he communicated me after 1 week or 2 weeks that he couldn't do it. So maybe I may get the furniture from the market, but that token money is not enough. The return of that token money is not enough. This is the remedy provided by the common law. The money I have spent, if I will get that money, the common law is justified. But as far as the equity is concerned, this return of token money is not compensate me. How they will compensate me? Maybe the furniture which I will get in 1 month may cost me sterling 10,000, but the same furniture which I may get within 2 weeks cost me sterling 20,000. Now this difference must be paid to me by the previous vendor. So this is the position, because this is the equity, this is the remedy provided by equity, that I must be restored into the pre-contract position. Clear? The concept of recession is clear. Good. Okay. What is the journal rule? Where equity rules, where equity rules conflict with the common law rules, the equity law will prevail. Yes, as far as the equity is concerned, as far as the equity law is concerned, the token money which I have paid, the return of that token money is not enough as far as the equity is concerned. What the equity will say, maybe after 2 weeks of my contract, the same furniture is available in the market, but not in sterling 10,000, because previously the vendor have to provide that furniture to me within 1 month, and now I have to get that furniture within 2 weeks. So this shorten of time may increase the price of the contract. So before selecting any two of the vendor, I was with the aim of opening a school within 1 month. 2 weeks which was wasted by my existing vendor will be paid off, because now I cannot get that the same furniture in the sterling 10,000. Now I will get that furniture in sterling 20,000. Now the previous vendor is required to provide me the token money and the additional money which I need to get that type of furniture from the existing market. Clear? What the common law says, only monetary compensation. If we talk about the common law, then the return of the token money is the fair the compensation. But if we talk about the equity law, then the compensation, storing me into the pre-contract position is important, and it is important how I will become into the pre-contract position, and the pre-contract position is determined in every individual case according to the scenario. Clear? Good. Okay. A very important rule, which is the journal rule about the equity law and the common law. When there is a conflict between equity law and the common law, we will always follow the equity law. What I'm saying, where equity rules conflict with common law rules, then equity law will prevail. Clear? In the case of conflict in between common law and equity law, which will prevail? Equity law will prevail. Okay. Doctrine of judicial precedent. The second part. Okay. What is the doctrine of judicial precedent? Okay. Journal rule is a court decision which is consistent with the previous case decision. It is called the doctrine of judicial precedent. When it can be consistent, when we can say that the same nature case, the same nature case arise in future, then the case we decide, then the decision we have taken in the previous case will be followed on the same nature case in the future. We can say a case is consistent if it provides direction for future relationship. How? Okay. Forget about the word doctrine of judicial precedent. We talk about the word consistency. Okay. In a court, a case is presented in which there is party A and there is party B. There is a dispute in between the case, and after the tracking, they are on the case management and a timetable is issued to them. Now, the court, the jury, will listen to one party, then they will listen to the other party. They will note their opinions. They will note the matter of case. They will note the dispute. They will note the facts of the case. What are the facts? What is the story of the case? How a wrong act is conducted. Then they call the evidences. Party A will be given a chance to provide their evidence. Party B will be given a chance to provide their evidences. And after taking the evidences, the court will evaluate those evidences. The arguments of both parties will be listened by the jury and also noted by the courts, right? After the analysis of the evidences, the court may come to a decision that party A is right and party B is on wrong side. So party B needs to compensate A. So this is the procedure how a case is resolved. Okay. This case is resolved and this case is also noted into the court. You may see in the movies and dramas that there is a one person sitting on the left or right side of the judge and noting all the things, noting all the things. What he was doing, he is making the summary of that case. Okay. Now, what is called the consistency? Consistency is once a case came into the court and then it is decided, its decision is taken. And after that case, in future, if same nature case come into the court, then the same decision will be applied. If the nature of case is same. If we follow the same decision on the same nature case, it is called the doctrine of judicial precedent, which is based on the consistency. The facts, the story is consistent with the previous case. So the same decision can be taken into the current case, right? So we say that the previous case provide the guidelines for the current case. Clear? So this is called the doctrine of judicial precedent. If the case is consistent, we will say apply the same decision on the basis of consistency, and this is called the doctrine of judicial precedent. And if the nature of case is different, then the same decision will not be followed. So if the nature of the case is different, then the same decision will also not be followed. So this will call the persuasive precedent. Okay, persuasive precedent is also part of this area, but firstly I need to make you clear about the doctrine of judicial precedent, which is a court decision consistent and provide direction for future relationship. It is consistent with the previous case decision. It has same nature, so there will be a same decision. It is called the doctrine of judicial precedent. Then it is based on consistency. For consistency, a technical term is used which is called the maxim stare decisis, which mean to stand by a decision. First, decide a case and then stand by that case. Stand by that case, which means apply the same decision on the a subsequent case if the nature of case is similar. Right? Same nature case, same decision. It is called the precedent. Previous court decision which another court is bound to follow by deciding a subsequent case in the same way, provided no material difference in the facts. Precedent become binding in nature. Journal rule, doctrine of judicial precedent is binding in nature. Okay, the concept of doctrine of judicial precedent is clear. Okay, very good. Okay, now the elements of the case. This is report, rules and clarification. What is the report? Report on the earlier decision. But I have said that the person sitting on the right or left side of the judge, note all the things. He is reporting. He is making the reports. Then he extracts the main things, myths of the case. Rule is extract of previous case, apply on the current case, and clarification whether the precedent, the rule decided on the base of that report is binding or not binding. When it is binding, it will call the judicial precedent, and when it is not binding, then it is called the persuasive precedent. How it will become the persuasive precedent? On the basis of different facts, on the basis of different nature, on the basis of different story, on the basis of different facts, right? So the clarification, if a precedent is binding, then it will be called the doctrine of judicial precedent. When it is not binding, then it will call the persuasive precedent. Why a precedent is not binding on the subsequent cases? If it has distinguishing facts. Clear? Okay. Ratio doesn't die and obiter dicta. I just want to give you the concept of, okay, read this persuasive precedent first and tell me it is clear to you. This. Please go through with the persuasive precedent and tell me if it is clear to you. Okay, what about the others? What about the other participants? Then I'll explain it. Where are the other participants? Are you with me? Hello, hello, are you with me? Do respond the other participants. Yes, okay. See, where an earlier decision was made by our lower court. Okay, good. Uh, where an earlier decision was made by a lower court, the judge can overrule the ratio of the earlier case. Okay. If they disagree with the lower court statement of the law, the court of the earlier judgment remains the same, but will not be followed in the future. Okay. This is the explanation of the diagram which was previously mentioned in your shown in your screen, that if there are same facts, then it is doctrine of judicial precedent. But if facts are different, then it is called the persuasive precedent. Okay, judicial precedent, same case, same nature case, same decision will be applied. Distinguishing facts, then that means the nature of case, the nature of matter is not same. So the previous case decision cannot be applied on the subsequent case. This is, it says, the outcome of the earlier judgment remains the same but will not be followed into the future. This paragraph is clear? Okay. What is the next paragraph? It says, if the decision of a lower court is appealed to the higher one, right? In this case, it is saying if a decision is made by the magistrate court, this is about the first paragraph, magistrate court, and it is appealed in the county court. So county court will see if it is same in nature, then the same decision will be followed. But if it is not same in nature, then the previous case decision, the reference case decision will be same, and the current case decision will be altered as per the current circumstances. Now, what about the second paragraph? If the decision of a lower court is appealed to be higher one, the higher court may have reversed the results. The county court may assume that the magistrate court resolved the previous cause with lack of care. Then the county court has right to not only change the current case decision but also the decision of the case of the magistrate court. Right? This is called the reversing. Again, after the point 6, we will discuss the concept of overrule and reverse. But now, what we are doing, first thing we are saying, if the facts of the cases are same, then the same case decision will be applied. This will be called the judicial precedent. If the facts of the case is different, then the same then the decision will also be the different. So when we are not following the decision of the previous case, this is called the persuasive precedent. Now, what it is saying sometimes when court is deciding a case, higher court is hearing the appeal of the lower court, the higher court may see that the previous case which was decided in the lower court was not decided correctly. So the higher court has authority to not only give the decision of the current case, but also change the decision of the previous lower court. Clear? Now this paragraph is clear to you. Very good. Okay. The next is overruling and reversing. What is overrule and what is reverse? Decision made by the lower court, previous case decision remain the same, current case decision change not in the light of previous case. Overruling is the case when a persuasive precedent is followed. We say if the case is of same nature like the previous one, we follow the same rule. But if the facts are different from the previous case, we will not follow the previous case decision, but we will decide the case according to the current scenario. This is called that we are not following, we are not taking the reference of previous case. This is saying we are overruling the decision of previous case. Reversing means when the high court change the decision of the previous case and for the current case. This is called the reversing. Do read it and tell me whether this overruling and reversing is clear. Reverse means change the case, change the decision, and overrule means ignore the decision. Read it and tell me whether the overrule and reverse is clear. Okay, very good. Okay, now let's have the understanding of avoiding of a binding precedent. Okay, before the avoiding of the binding precedent, we are left with few concepts which are ratio decidendi and obiter dicta. Now, what is ratio decidendi and obiter dicta? Okay, ratio decidendi and obiter dicta as the judicial precedent and the persuasive precedent is about the decisions of the courts. The ratio decidendi and obiter dicta is about the arguments or the statements of the parties, right? Okay. Ratio decidendi and obiter dicta are these statements of the judges. The statement of the judges are of two types. One is called the ratio decidendi and second is the obiter dicta. What is the ratio decidendi? Ratio decidendi are the statements and facts which leads to final decision, which are the reason or basis of decision. Other than the statements which leads to the decision are called the obiter dicta. Other than the clear facts not leading decision, statements said by the way do not form the basis of decision are the obiter dicta. So in the arguments of the parties and the statement of the judges are two types. Either a statement is ratio decidendi or the obiter dicta. The statement which guides the judge towards the final decision is called the ratio decidendi, which is backed by evidence, which is supported by evidence, which is proved in the court, right? The statement other than the ratio decidendi is called the obiter dicta. Obiter dicta, that means these are the statements which are said by the way, right? So the concept of ratio decidendi and obiter dicta is clear. Is this ratio decidendi and obiter dicta is clear? Yes, obviously, if the statements are obiter dictas, these are the journal statements said by the way just to support one argument. So the obiter dictas are statements which are not supported by evidence, which are not argued by the parties, which are just said by the way to support one statement. So these do not help judges to conclude the decision. So judges cannot make the decision on the basis of the statements which are just said by the way, right? So obiter dictas are the statements which are not supported by the evidences. Clear? Okay, it is written here, statements said by the way do not form the basis of the decision. Clear? Okay, now the status of courts. You will read the status of court and you will tell me if it is not clear. Tell me. Read it carefully. Take 5 minutes, read it and tell me if it is not clear. The status of court is the basically the explanation of the court structure, which we have already done, the civil court structure and the criminal one, right? This is about the civil court structure, the status of courts. Take the 5 minutes and do read it. Actually, these judges are sitting alone in their respective divisions, right? In the divisional court, court of appeal, Supreme Court, European Court of Justice. Right? When the different divisions are involved, they are judging sitting alone means sitting in their own division. Okay, very good. Okay, one thing which you all noticed, that there is an exception of the Court of Appeal, right? All inferior English courts are bound by the decision and itself, but there is some exception. Court of Appeal exception, general rule, Court of Appeal is usually by its own decision and the decision of the Supreme Court, exception. Two previous cases conflict, difficult to decide which case to apply. If the facts of the two previous cases are more same, and it is difficult to decide which to follow, then the Court of Appeal follow the decision of the High Court. Previous case decision conflict with the decision of the Supreme Court, then Supreme Court decision will be followed. Previous case decision made with lack of care. If the Court of Appeals decision is taken with lack of care, then the Supreme Court decision will be followed. If there is a conflict in between the Court of Appeal and Supreme Court decision will be applied. If there is a conflict in between the uh, decision of the current and previous case, then again the case will be decided by the Supreme Court. Clear? Okay. Now, avoiding of the binding precedent. Conflict with fundamental principle of law. Distinguishing facts. Ratio descendi is obscure. Ratio descendi is not confirmed. Previous precedent is so much wide that guideline for subsequent case cannot be obtained. Previous case decision carelessly taken, which is called pre-incurrum. Okay, this at the point 8, there are the point in which we are saying that how you can avoid a binding precedent. First, if it is conflict with the law, if a binding precedent conflict with the law, then what we will do, we will avoid the binding precedent. Second, if the facts of one case is different from the facts of the previous case, then we can avoid the binding precedent. If the ratio descendi is not clear, then we can avoid the binding precedent. If the previous case is so, the CN is so wide that it is not easy to take the guidelines from that case, then we can avoid that binding precedent. And if the previous case, the CN which we are considering for the reference is handled carelessly, is not the decision is not taking with care, then what we will do, we will avoid the binding precedent. Clear? Advantages of the judicial precedent and disadvantages. Do read it and tell me if these are clear. They are flexible, they are detailed, they are practical, they are already in practice. Details is already available, they are consistent, the similarities are found. So these are the advantages of the judicial precedent. And disadvantages, there may be so many cases and you are unable to identify which case is to be considered for, which case is to be considered for the reference. And there may be some unfair precedent, the precedent which do not fall or which is do not same with the current case, and they may restrict the discussion of judges. And maybe the facts, if the facts are not same and you apply the decision, then the decision is also unfair. Okay. Okay. Okay, give me a break of 7 to 10 minutes, and then we will start with the other area of legislation, right? A 10 minutes break. We'll start. All right. Okay. Can you hear me? Can you hear me? Can you see the screen? Okay. Legislation. Legislation is the type of law. Okay. Annotate, and this is the option. Okay. Legislation is this statute law made by the parliament. Okay. When we are studying the statute law, what we were discussing that public elects some persons with multiple or different skill sets. They combine the persons having different skill set together just for the purpose of having guidance each and every area they are dealing with. So the person who are sitting, the elected person by the general public sitting together are called the parliament. So any law which is decided in the parliament is called the statute law. So any law which is statute law is also called the legislation. Okay. Parliament is sworn. That means parliament is independent, and the parliament is it has right to make a new law, end the new law, modify the new law, reverse a law, or overrule a law. So what is the parliament's sovereignty? Reappeal earlier status, overrule or modify, make new law. Conventions which limit the parliament's sovereignty. No parliament can present a future parliament changing. Right? So no parliament can challenge the any parliament. So validity cannot be questioned, but may be incompatible with the HRA. Any law which is decided in the parliament cannot be questioned, but it may have a conflict with Human Right Act. So if there is any conflict between the law made by the parliament and Human Right Act, then where the course will go into the European Convention of Human Right Act, which works equivalent to the Supreme Court of the every country. Clear? So if there is a conflict in between Human Right Act and any legislation, then there is that this a statement of incompatibility should be submitted to the European Convention of Human Right Act. Interpret statute law by their own sense, which may be inconsistent with the actual law. Yes, there is also a problem that when a law is made, it must be interpreted. It must be interpreted so that the persons who are going to apply that law on the subsequent cases must understand all the technical terms, words, and statement in that. If the interpretation of the legislation is not consistent, then ambiguity may arise. Right? So legislation is any law which is decided by the Parliament. Okay. What are the types? Public effect general public, private effect specific group of individual, and third type of legislation is delegated legislation. When it is the same case as we say that one court cannot handle the matters of all nature. So they divided the court structure, they make a court structure and divided the responsibilities to solve the cases. Same is the case in the legislation. What they did in some cases, in a very frequent nature cases, they delegate the authority to resolve the dispute through the concept of delegated legislation. They delegate their powers to resolve the case to some authorities so that the cases can be managed timely and properly without wasting time. So, what is the delegated legislation? Delegated legislation empower a specific individual or body to produce the detail required by the Parent Act. Procedure. How this is the delegated legislation is the transferring of power as the court structure transfer the power of handling of employment matters to the employment tribunals. See, a court, a tribunal, uh, which is working equivalent to the High Court. So it is working equivalent to the High Court. So what the court structure did, they authorized the tribunal to handle the disputes. So this is one type of delegation of powers to resolve the disputes. Clear? Now, what is the procedure of legislation? First, stage 1, stage 2, then committee stage, then report stage, then reading stage. First, reading of publication and introduction of the agenda, no debate. Second, reading debate on the journal, insist of bill, no amendments. At first stage, agenda about will mean the problem to whom you are going to solve, the problem for you are going to make the new rule. So in the first stage, stage 1, the first reading stage in which the agenda is presented and the introduction of agenda is given. So in stage 2, they read the agenda, they read the agenda and they give the arguments, but there is no amendment in the agenda. In the committee stage, this agenda, this bill is examined, its pros and cons is discussed, and a conclusion is presented. Report stage, now the bill is amended and presented to the whole parliament for the approval. And third reading stage, when they approve the decision. Clear? This is the procedure how a parliament decides, makes a law. Clear? Second, advantages and disadvantages of the legislation. Do read it. Do read these advantages and disadvantages. Okay, first advantage is responsive to public opinion because the persons elected by the general public are making the laws. Deal any problem. These are carefully constructed because the persons who have multiple skills, the pool of expertise are involved to make a legislation, respond to problem in society or case law. Obviously, the public representatives are available to deal with the matters, so they are well aware of the problems in the society. So they try to solve those matters. And disadvantages, sometimes if there are so many persons, there are so many opinions, so it will become bulky and it take lot of time, and there may be some details which are irrelevant, and at the end sometimes they do not predict the future situation, so they make the law which do not fit for the future situations. So these are the advantages and disadvantages of the legislation. Okay, delegated legislation is a detailed law. It is made by the subordinate bodies to whom power to do so has been given for by status. I have just given the example of employment tribunal. Delegated legislation appear in various forums. It is given to the ministers, to local authorities, rule of court, professional regulations, and other orders in council like Privy Council. Privy Council is also the example of the delegated legislation. Okay, what are the advantages and disadvantages of the delegated legislation? It saves parliament time, include professional and technical opinion. If new or altered legislation is required, they can issue without referring back to the parliament. In delegated legislation, they can make new legislation, law enact quickly. Disadvantages, there is no accountability, it is difficult to up to date, and power to civil servants who are democratically elected are given, which may use them as wrongly. Clear? So these are the advantages and disadvantages of the delegated legislation. Now, the very okay, what we are studied till now is the law, types of law, civil court structures, criminal court structures, Civil Procedure Act 1998, and then sources of law. In sources law of, there are two sources of law through which law can be made. One is case law and the second is legislation. In case law, we have studied the so many concepts like doctrine of judicial precedent, persuasive precedent, ratio decidendi, structure of courts, and then legislation. In legislation, one is the concept of legislation and second is the concept of delegated legislation, when you delegate your power to someone other to handle the dispute. Now, the law is made, the law is introduced, the law is developed, the law is made. Now, the third element is interpretation, explanation of the law. Okay. Now, why this interpretation of law is important? Just to facilitate the implementers of the law, to make them understand that what it says, why it is made, what is the purpose of the law. We need to understand the implementers that the purpose of the law is this, the technical language used for the making of law, the explanation of the terms of the language which is used in the making of the law. So statutory interpretation means we have made a law and now we are going to interpret the law so that the persons who are going to implement that law may have the proper knowledge of the law so they can implement them accurately, right? So statutory interpretation, legislation must be interpreted correctly before judges can apply it fairly. To apply the legislation, judges must first interpret and understand it. Problem occurs when the judges has difficulty interpreting the statute. There are a number of situations which might lead to a need for interpretation. What is the problem? When it is ambiguity, there is ambiguity, there is uncertainty, there is unforeseeable developments, and when there are broader terms, then it is difficult to interpret or to understand a law. So if there is uncertainty, ambiguity and broader terms, so it is difficult for the implementers of law to understand it, and if it is difficult to understand, then they cannot apply them accurately. So the court introduces the concept of interpretation. They interpret the law by the three means: first, rules; second, presumption; and third, other rules, intrinsic or extrinsic aids, right? Intrinsic and extrinsic aids. Okay, let's do them one by one. Okay, rule. The literal rule. There are 5 rules. The literal rule, lateral rule, golden rule, mischief rule, purposive approach, and contextual approach. Literal rules say that take the literal and grammatical meaning of words used rather than what they judges think. Golden rule take the plain and ordinary meaning of the term used in the law. Mischief rule take the rule which suits on the action, which suits on the act. Purposive rule is the combination of literal and golden and purpose of the law. What is the purpose of the law? And contextual rule, which follow the context of the law, is called the contextual rule, in which you will follow the reason why this law is made. So these are the rule: literal, golden, mischief, purposive, and contextual. Contextual rule which follow the context, purposive rule which follow the purpose, mischief rule which apply on this certain act, golden rule plain meaning, and literal rule grammatical meaning, right? Second source of interpretation is presumption. If no expression, then we can presume things. We can assume things, and assumptions can be changed. And in law, if we change an assumption, we say we rebut. We are changing. We are altering the assumption. What is the assumption? Our thinking, which is not based on facts, right? So a statute does not alter an existing common law if a statute is capable of two interpretation, one involving alteration of the common law and the other one not. The later interpretation is to be preferred. It says in presumptions, if an existing common law is conflict with the presumption, says that you in one scenario you are required to alter a rule, in other scenario you are not required to alter a rule, then the other scenario in which the alteration is not required will be followed. Every person should be compensated. Status does not repeal other statutes. Not bound Crown Court. The presumptions are not bound on the Crown Court. These are only effective in the UK. They cannot impose criminal liability without proof. Obviously, once you have to prove a crime, you have to prove it. Status cannot have retrospective effect. That means it has not effective before the decision is taken. It is only effected after the decision, right? Other ends. Other end, the Interpretation Act 1978 define various terms which frequently used like gender, masculine, feminine, singular, plural. Right? Infringing Act, long title of an act. This is the guidance for act general rule. Preamble of act, this is the story, this is the introduction which is given before the before the rule, just to make you understand what is rule about. Interpretation section of act, long title of act, self-explanatory. Journal terms are written on a written with the meaning, so that when you are reading the rule, you may understand these journal terms are used and this is the meaning of those journal terms. Side notes, you often says on the books, the side notes are made in the boxes, in the blocks, in the circles, just to make you understand the important information in that paragraph. So the same is the make in the the same is the case with the law rule books, in which the laws are mentioned. The keynotes are, the side notes are made so that you can emphasis on the key areas. So these are the intrinsic aid, and extrinsic aids are the aids which are published in some gazettes, in some reports, in some reports of the parliament. So law reports are circulated with regular intervals, in which the interpretation of law is involved, and housed parliament journals. These are the journal, which is again, these are the periodicals which are updated over the year and spread and circulated into the members of the parliament, so that they can make themselves updated. Clear? Clear? Okay. The very last topic. Human Right Act. The impact of new legislation. The impact of new legislation. The impact of statutory interpretation and the common law. Okay. We have studied about the Human Right Act. All right. We have studied about the Human Right Act, and we said that in every country, the countries who agreed on the Human Right Act must follow them. If they do not follow, or if they have any conflict with the Human Right Act, then this conflict will be solved in the European Convention of Human Rights. Okay. How this can conflict? Okay. We said we make a law, and then we have said it is developed over here, and then we said that there are two sources of law, and then we interpret the law just to understand it, how to apply it. So these three stages in which law is made, right? Law is interpreted and law is introduced. So in these three stages, we need to check time to time that the making of new law, common law, the making of legislation, the law in the statute, and the interpretation of the law should not be inconsistent with the Human Right Act. So in this area, the act of human right, the impact of the common law, the legislation, and the interpretation of law will be discussed in the impact of Human Right Act. So first, if there is any conflict between a common law and Human Right Act, then there must be compatibility. Common law must be made according to the Human Right Act. But in the case of new legislation, and statutory interpretation. If there is any conflict in between Human Right Act or legislation or interpretation, then a statement of compatibility is required to be submitted that this act or this interpretation is in conflict with the Human Right Act. To whom this statement is submitted? Into the European Convention of Human Rights. Now, do read this impact and tell me if it is clear or not. The impact of Human Right Act with the statutory interpretation. Okay, the statutory interpretation is when a law is made and you are going to interpret it. This interpretation must be compatible with the Human Right Act, right? Uh, so whenever you explain a law, you interpret a law, that explanation must be according to the Human Right Act, right? The explanation must protect the aspects of Human Right Act. Okay, now it is clear to you. Okay, good. What about other participants? Okay, very good. Okay. This is our today's class objective, and by the end of this objective, we are done with the very important element, important area of our exam, our detailed syllabus, which is, let me show you. The English legal system. See what we have done. Okay, we are done. The essential element of legal system. Law and legal system: define law and distinguish types of law. Explain the structure and operation of courts. Second, sources of law. Explain what is meant by the case law and precedent. explain legislation and evaluate the delegate legislation, illustrate the rules and presumptions used by courts interpreting statutes, identify the concept and impact of human right laws. See, we are done with the part A of our syllabus. You get that? Okay. Coming to the course plan. You can see the course plan? Yes. Okay. Coming to the course plan, by the end of today's class, the 19th January, we are done with the sources of law. In our next class, we will be going through with the part B of our syllabus, which is the law of obligation, in which firstly we will practice some questions of the area we have just covered, the English legal system. Practice of English legal system. That means you are required to read the whatever concepts I have given to you in the English legal system before the next class, because in our next class we will practice the question relating to the English legal system, right? And then we will go for the other concept, which is called formation of contract, validity of contract, freedom of contract, elements of contract, then what is offer, supply of information, invitation to treat, termination and offer, right? So these areas will be covered in our next class, in the class of 26th January. Clear? Okay. Do request Hamzah Academy to add you in the WhatsApp group. So during the week, if you feel any question during the study of detailed notes of Hamzah Academy, you can text me on that WhatsApp group and I will explain it. So in this pattern, we will be prepare our topic as well, not only concept wise, but also practice wise. So this is what I commit in our first class, that I want you to spend maximum time in the class and practice maximum question in the class, so that you can spend less time after the class on this paper, right? So what you need to do, you need to revise the whole English legal system. And if you feel any problem, if you do not understand any question, do let me know in that WhatsApp group, so that I can explain that concept as early as I can, probably probably within the same day, so that you can understand it, and we will practice the covered area in the upcoming class. Clear? Okay, I am done. I am done with my today's lecture. And if you have, please go through with it. And if you have any question, you can ask. Otherwise, I'll end the class. Do you have any problem? Or I can quit the class? Okay. Okay, then goodbye from my side. God bless you. Goodbye.